The UK government has started a major review of its settlement rules. This review is part of a consultation document. The document is called A Fairer Pathway to Settlement. Settlement is also known as Indefinite Leave to Remain, or ILR. It gives people the right to live and work in the UK permanently. The biggest change proposed is the standard time it takes to get ILR. The government wants to move this from 5 years to 10 years. This would become the new default for many people on work visas and family visas. The consultation is an important step. It allows the public and experts to give their views before the rules are changed. This is a very significant proposal, and the consultation period is open to everyone. It started on 22nd November 2025. It will close at 11:59 p.m. on 12th February 2026. The changes aim to create what the government calls an earned settlement system. Staying permanently must be earned over a longer period, and it also means meeting a stricter set of criteria across a wide range of immigration routes. It could affect many who have already started their lives here. Understanding this proposal is critical for anyone on the path to settlement. This is, a really pivotal moment. While the standard route to settlement may become longer, the plan includes an exception. There will be a fast-track option for high earners. The government has proposed that people earning more than £125,000 per year can apply for ILR after just 3 years. This was announced by the Home Secretary. It is designed to attract and retain top talent, sending a message that the UK remains open to very highly skilled and highly paid individuals, a significant incentive for those in senior roles across finance, technology and law. Alongside the timing changes, the government is introducing new tests to prove settlement has been earned. There are 3 main requirements. First, an applicant must have a clean criminal record. Any significant offence could bar them from settlement, raising the standard for good character. Second, applicants will need to prove they can speak English to an A-level standard, a higher level than is currently required, and likely needing new forms of testing. Third, applicants must show sustained national insurance contributions, demonstrating consistent work and paying into the system. These requirements will act as a strict barrier. Failing any one test could disqualify someone, even after 10 years or more in the UK. The A-level English standard will be a challenge for many. Sustained NI contributions mean long gaps for childcare or illness could create problems. One of the most controversial parts is its retroactive effect. The consultation says the new rules could apply to everyone in the UK now who does not yet have ILR. That could mean people who arrived under the 5-year rule no longer qualify. The Home Secretary says changes would start being implemented from April 2026. Imagine someone due to reach 5 years in May 2026 suddenly having to wait another 5 years. Many see that as deeply unfair. A petition titled "Keep the 5-Year ILR Pathway for Existing Skilled Worker Visa Holders" argues changes should only apply to future arrivals, and that people already here came in good faith. It had over 157,000 signatures and triggered a debate in Parliament. Several MPs have publicly raised concerns, noting skilled workers in health, engineering and social care are vital and already contribute. Many say changing rules mid-journey feels like moving the goalposts, creating uncertainty and distress for families. At its core, the argument is about fairness and trust. An early-day motion calls for protecting the 5-year route for those already on it, showing concern across the political spectrum. The government will need to address these fairness issues in its final decision. To understand the impact, imagine a software engineer named Sarah. She arrived in the UK on a skilled worker visa in January 2021. Under the current system, she planned to apply for ILR in January 2026, after 5 years of continuous residence. She has a good job, pays her taxes, and is settled in her local community. Her family's plans rely on that date. The new rules are expected from April 2026 and may apply to those without ILR by then. Sarah might apply under old rules, but delays or earlier changes could push her onto a 10-year route, shifting settlement to 2031. The new tests would also apply A-level English, a clean criminal record, and sustained national insurance contributions. Any long employment gaps could put her application at risk. Unless she earns over £125,000 for the 3-year fast track, this uncertainty mirrors what thousands like Sarah now face. Lives in limbo, hard to plan with real financial consequences. For now, remember, the rules have not changed yet. The government is consulting on a proposal. Today, the 5-year route to ILR is still in place. If you are eligible to apply under current rules, do so. Do not wait. Experts recommend submitting as soon as you qualify, so your case is decided under today's system. Check your dates, your UK entry date, and when you complete 5 years of continuous residence. If that date is before April 2026, you may apply under the current system. Review the exact continuous residence rules. Long absences can break continuity and reset the clock. Organise your evidence, pay slips, P60s, and proof of residence covering the full period. Preparation is your best defence. Follow the consultation to the 12th of February 2026, the parliamentary petition and MP debates. Track reliable news and official announcements. Seek professional advice to check eligibility, prepare your application, and understand risks. Apply now if you can. Check your dates, stay informed, and get expert help.